Well, welcome everyone. We'll get 7:30 here. We'll get rolling. Just want to welcome everyone to tonight's webinar. I'm Mike Anderson. I'm a partner with MMP based out of our South Surrey office, and I lead our professional services group within the Greater Vancouver area. So, why we're here tonight? I think over the last 2-3 months now, everyone on this line has had to make a lot of hard decisions. I imagine a lot of decisions that never in a million years would have a lot of you thought you would have ever had to make. But as you've gone through those decisions, I think it's probably become clear that there's a lot of interaction between tax and legal matters that sort of correlate throughout the decisions that you're making. And so we thought it'd be a good idea to bring on a couple experts from, one from a tax background and two from a legal background and employment law background in particular, just to maybe help us understand how some of these decisions you're making as you're starting to reopen your practice impact you going forward, and how do you best protect yourself. So with me tonight, I've got Danny Bernstein on the line. Danny's an employment lawyer with Roper Greyell. Roper Greyell is an employment law firm based in Vancouver. Danny's got a fair bit or significant experience with labor law, employment law, as well as human rights law. And in particular, Danny does work with lots of businesses in different industries, but he does spend a lot of his time working with individuals that have healthcare practices on their employment matters. I've also got Marty Clement. Marty's one of my partners who's based out of our Kelowna office. Marty is a Canadian tax specialist and spends most of his time in his practice working with our clients throughout BC and throughout the country as well on Canadian tax planning matters. So that's in particular working with our professional clients. So before I hand it off to Danny and Marty to run with sort of their pieces, I guess first off, just wanted to touch on a couple of housekeeping things. So we did get put out a list of or a request for questions to address as we go throughout the presentation. And I guess first, just wanted to thank everyone for the questions that got posed. It was quite overwhelming, the list of questions that we had. We actually added it up to 4 pages at the end of the day. So a lot of great questions, but unfortunately, we probably need a good full day here to be able to get through all those questions. So there's definitely some hot topics, and we're going to do our best to sort of focus the presentation and the Q&A portion around some of those hot topics. So one thing you'll note is in the bottom right corner of your screen, there is a Q&A section. So if you do have questions as we go through the webinar, feel free to post them into there. I'll be sort of watching on the back end, and we're going to save about a half an hour on the back end of this to ask questions of Marty and Danny. So I'll accumulate those questions, and we'll do our best to get through as many of those as we can. And the reality is we probably won't get to a lot of the questions. So if you do have questions that you haven't got answered through this presentation, please feel free to reach out to Danny, Marty, or myself after the presentation. We'll be happy to either try our best to answer the question or direct you to one of our colleagues who can help you out with your question. And before I turn it over to Danny to start with the employment law stuff, just a quick reminder that this is being recorded, and our marketing group will be distributing out the recording of this webinar probably early next week. So that said, I will hand things over to Danny.
Yeah, thanks, Mike, and thanks everyone for joining us this evening. Really appreciate you guys giving us your time. As Mike pointed out, it's been a hectic few months. I've spoken, I think, with a few of you who are on this call and lots of clients in terms of how to first manage when we were closing down. And now, thankfully, for a lot of us, we're looking at tooling back up again. So there's a lot of questions that come with that. Thanks to everyone who submitted questions in advance. We will not get to all of them, unfortunately, but what I will try and do is follow up with each of you who had an employment law question at least. I'll try and reach out to you to see if I can help answer your question. But if I don't, or if you need to get me, you've got my contact information at the end here, so feel free to reach out directly. In terms of my presentation, I've sort of picked 3 main areas that I'm going to touch on. And then there's going to be questions and answers, and hopefully we can walk through some real life scenarios that you're all experiencing and sort of put it into practice what we're talking about. The first issue that we want to talk about is safety requirements, because I'm sure, as a lot of you are aware and have read and have heard, one of the major hurdles to reopening, if you will, or an issue that had to be cleared was you needed to be able to do so safely. And we heard from the Premier and Minister of Labour and WorkSafe BC, who regulates safety, that what you need is a safety plan. And the concept of a safe workplace is not new. It's embedded in our workers' compensation legislation already. Every employer already had an obligation to provide a WorkSafe that was free from hazards and as materially reduced risk as possible. But we now have this very explicit requirement for what's a safety plan, which previously wasn't a requirement. Thankfully, WorkSafe BC have created a template. So for all of you who haven't navigated over to the WorkSafe BC COVID website, it is very helpful. It's full of very useful information, including a safety plan template. So I do encourage you to go and check that out. I've got a link in the slides here, which is they've actually created material specific to a bunch of different businesses and a bunch of different industries. And there is a health professionals entire section dedicated to health professionals, and it'll walk you through the preparation of the safety plan and other considerations that you'll need to take into account. One thing I wanted to clarify, because I've heard this from a few different folks, is that you do not need approval to open. You do not need, at least from WorkSafe BC or the government, different from a regulatory body like your own governing body, but from the provincial government, you don't need to send your plan in. There's no one who needs to approve it. WorkSafe BC is not looking at it or reviewing it in advance. You do need to have one, because if you are audited, if there's any reason for WorkSafe BC to be on your premises, they will ask to see it. And for that reason, it has to be posted in a visible place for the public and your employees at a work site. One point that's really important that I think may be missed, so it's important to highlight here, is you need to address how you're going to deal with sick employees. It is not the same as it was before. We are not going to be okay with having people sick at work. Whereas I know before, and I work in an office, so there was always 1 or 2 or 3 people who had a bad cold, and everyone would look at them and say, I wish they weren't here, but no one would have told them to go home. No one would have stopped them at the door. But now I encourage everyone to have even a very basic sick leave policy as part of your safety plan that tells employees, your staff, that they cannot come to work if they're sick. That doesn't mean you have to pay them sick pay. It means you have to prevent them from coming to work while they're sick and put in place a system to deal with their absences, as well as perhaps improving or creating some communication channels so that employees can easily identify when they're not going to be at work. It does raise the question of paid sick leave. It is certainly not mandatory for this purpose that you have paid sick leave. Obviously, if someone has COVID symptoms, they're going to be off for some time. They may qualify for employment insurance or other social security payments, but you do not have to pay it. You can. If you are going to decide to pay sick leave, again, you need a policy that sets it out, and you want to carefully consider some flow-on effects from that. For example, how much can it accumulate? Are you going to pay it out year after year? Is it a use it or lose it? And there's more to it than just simply saying we'll pay for sick leave. So that's something that I encourage all of you to address. I'm going to speak about what to do with people who are refusing to come to work for safety concerns. I'll deal with that a little in the next slide or the one following. So for now, on safety requirements, this is focused on the safety of your workplace. Obviously, you're following all of the guidance from our provincial health officer and your governing body, and in terms of what mechanisms you need to have in place, what procedures, what policies you need to have in place to ensure that your staff, any visitors, the public, anyone else who comes onto your premises can be as safe as possible. We know this is not a standard of perfection. It is impossible to guarantee someone will not get sick, but you are taking all reasonable precautions. I'm going to put it in quotes here. All reasonable precautions is the test that WorkSafe will look at in terms of whether you've created a safe workplace. And if you can point to following the provincial health officer, following your regulatory body, having a safety plan, having the policies in place and enforcing them, then that is the due diligence to protect yourself against any sort of claims from an employee who says they got sick at work. It's interesting, just as a side note, in Ontario, there is now a presumption that any employee who is working in an essential service who contracts COVID, it is deemed to have contracted it at work, which means the employer then has to disprove that they contracted it at work, which is a huge burden for employees. Let's hope that never makes its way across to BC. We didn't have the same business closures that Ontario did, but it's interesting to think that you really do have to you don't want to be paying premiums for someone who contracts COVID. And you don't want your experience rating to be harmed, so take all reasonable precautions. The next slide, switching gears, a lot of the questions that you all provided were around terminations. Unfortunately, that is a reality that we're all looking at right now. And terminations have either already been taking place or they're coming up. So one thing I wanted to explore, which is a common misunderstanding, there's two concepts of termination notice periods in our law here in BC and in every province. We have our Employment Standards Act, which I'm sure you're all familiar with. That is the minimum standard legislation in British Columbia. So that sets out hours of work, minimum wage, overtime, vacations, leaves of absence. Those are the minimums. You can't go below them. You have to comply. You can agree to provide more than, but you cannot go below employment standards. And it talks about statutory termination notice. So it says if you're going to dismiss someone without cause, without just cause, you have to give them a certain amount of pay in lieu of notice or working notice. And we now have this concept that I'm sure you're familiar with now with temporary layoffs, and it creates the temporary layoff period and tells us that if that period expires, there's a termination of employment. We also have this notion of common law notice, which is judge-made law or case-made law. And over time, our courts have said that the statute is merely a minimum, a floor, but in fact, it's not a ceiling, and employees may be entitled to more notice than just the statutory minimum. And to put it very simply, unless you have a contract with your employee that says you can terminate them by providing the statutory minimum, if you don't have a contract, or if your contract is silent about termination, then you're in this world of the common law. And what the common law says is that there's a whole range of factors like age and seniority and years of service and income and ability to find alternate employment. And all of those get put into a mix, and the courts come up with a common law or reasonable notice period, which bears no relation to the statutory notice period. So we've seen case law with employees who have only worked for 6 months getting a 6-month reasonable notice period, or employees with longer service periods. If you've got office staff is quite an often example, office assistant, a receptionist, technician who's been there 10, 12 years, you could be looking at a notice period of 9 to 12 months if you don't have a contract in place. So when you're considering terminations, you do need to be aware of whether you have contracts in place. If you're hiring new staff, it is just incumbent to get contracts in place. If you have any opportunity of promotions or other changes in employment, then again, look at getting a new contract in place. A common question we get is what happens when this temporary layoff period becomes permanent? We've heard that there was initially a 13-week temporary layoff period. It was extended to 16 weeks by change to the Employment Standards Act, intended to avoid terminations coming around, which really will start happening in June and then into July. It's only a concept under the Employment Standards Act, and it says that if you go beyond a temporary layoff period, so right now 16 weeks, in any 20-week period, the employee is deemed to be terminated, which means the employment is at an end and you owe them at least their statutory termination pay. And importantly, the deemed termination date is the date of first layoff. So you have to look at when they were laid off, and that's when you calculate service for them, and they're deemed to be terminated. So it is important to be aware of when your deemed termination dates come up. I know one strategy a lot of employers have used is to recall people from layoff, to re-employ them, even if there's no work to do or even if it's on different terms and conditions, and access the SUs to subsidize the income, the salary for them, so that they can avoid the application of this deemed termination date. So that's something that you might want to look at if you've got some liability coming up. Others have said that they're using this as an opportunity to part ways with employees who perhaps have been considering doing this in any event, and this is just an easier way for them to engage that. Always another question is paperwork. You certainly want to document any decisions or communications, so be it placing someone on layoff, be it terminating employment. You do want to have some sort of paperwork, paper trail that documents why the decision was made, what decision was made, what was offered, what was discussed. It usually follows on from a conversation to say this is what's happening. You follow up with a letter that says you're not being recalled because of the COVID-19 pandemic. We can't offer you any future work. Wish you all the best. Explain what's happening with benefits, their record of employment, when their termination pay will be paid out. But quite often in the panic and the rush here, we forget to document things, and then if there's ever a challenge later on, it's very difficult to recreate what happened. So a simple letter or paperwork can really help you to avoid some challenges in the future. Recalling employees is the last slide I have here, and then I'm going to hand over to Marty before I come back with some questions. Hopefully you're all in a position now or soon in the future to be recalling some employees to work. Again, first question and the first point I would make is document. If you've laid someone off, recall them with a recall notice. And this dovetails with the second point. You may want to, or you may need to recall them on different terms and conditions, different hours of work, different salary, maybe even different responsibilities. So your recall notice says, dear employee, you are laid off on X date. We're now recalling you as of X date. And if everything is the same as it was prior to the layoff, then that's really all you need to say. But if you need to change the hours of work, the salary, the wage structure, whatever it might be, you need to document that as of X date, by agreeing to be recalled to work, you are agreeing to the changes of either temporary or permanent changes of your terms and conditions, and you need to set them out. And that way you've got a document, you've got agreement to those changes. Everyone's on the same page, everyone understands what the situation is. I wouldn't recommend recalling people and then telling them, oh, by the way, now that you're back, you're only working part-time, or I'm reducing your income, or you've got different responsibilities. Address that up front. If they're going to say no, they're going to say no. You may owe them some termination pay, but I would rather have them come back with agreement on these changes so that you can go forward knowing that you're on good footing. One issue that I wanted to touch on, and I'm sure we'll return to in the questions, is people refusing to work. I think to get this straight in everyone's mind, start from a proposition that you as the employer are entitled to insist on people coming to work. That's the general rule. Every employer is entitled to require their employees to come to work. Employees can refuse as an exception, or the the exception to the general rule. And employees can refuse for a number of reasons. They may have a genuine COVID leave of absence or another sick leave. They may have a need to accommodate a disability or a family status commitment, for example, a family member that they are caring for. But I don't want to catch public transit. I'm just generally feeling ill at ease. I like getting this $2,000 a month for couch surfing. No, I'd rather take the summer off. None of those are genuine reasons for not coming back to work. And you can insist on an employee who gives you those reasons in coming back. And if they don't, then potentially they've abandoned their employment. So we do hear a lot of pushback from our clients that staff are saying, no, I really don't want to come back. The biggest one is, I just don't feel safe. You've got to drill down in that conversation, find out what it is that is unsafe, or their concern is, that's unsafe. It can't just be a general vague feeling of, I don't feel safe. You as the employer are entitled to say, I've done all of these things. I have a safety plan. I'm following the guidelines. I've got the screens up. I've got the sanitizing. I've got the this. You need to come to work unless you can identify a specific concern. And if they do, and they're actually refusing to come to work for that reason, then there's an entire process under the WorkSafe regime called a work refusal. And you have to engage a joint health and safety committee. You go through a process of identifying concerns, and ultimately WorkSafe can get involved. But my experience is that when you push back to an employee and say, what is it apart from this vague feeling? What is it that you're concerned with? They can't identify it. And then you can ask them, are you refusing to come to work? Because I am recalling you, are you refusing? And if you're refusing for safety reasons, you have to identify that. That usually bridges past that refusal, and you can work out an arrangement. So you start from the general that you're entitled to insist on people coming to work. Each case has to be dealt with individually. Don't use blanket rules. Don't be black and white. Look at people's circumstances, but don't simply accept, I don't want to right now, unless as the employer it suits you, unless you want to. The last point I'll cover here, what happens if things change? They may change. We all know that this seems to be going in the right direction, but we don't know what the future holds. There's talk of this second wave. In any recall notice, I've been using language that says we may have to lay you off again. I think you need to be open with your employees that you're doing your best, but you can't guarantee the future. You can't guarantee them hours of work. You can't guarantee them a certain period of employment or certain wages ongoing. And I think that the more you are transparent and open in that discussion, you will have the ability, if need be, to lay them off again or to change their terms again. Just as we did the first time. No one contemplated this, no one anticipated it, but we did it and we've made it through so far. So you definitely will be in a position to act again, and I would encourage you to just be open and transparent in all of your conversations so that it's not a surprise to anyone. So that's it from me for the beginning. A bit of a whirlwind, but I know we've got lots to cover. I will come back to answer questions. I'll pass over to Marty now.
Well, thanks very much, Danny. That was great. So I'll probably just spend the next 10 minutes, maybe 15 minutes talking about the wage subsidy programs, and I'll briefly talk about the CEBA loans and the rent subsidy, and then we'll get back into our questions. So we just got a general disclaimer here. I'm not going to get into this with too much details. Again, just like Mike and Danny said, we're going to have lots of time for questions as we can kind of conclude the presentation here. If for whatever reason we don't get to your question, again, feel free to contact your local M&P professional with, anything that's specific to your circumstances that you'd like to follow up on. So just the first program here that I'd just like to make some comments on is the temporary wage subsidy, or the 10% program. And I guess the general comments here is that this was the first program that was in fact legislated back in March when the sort of the pandemic was announced. This is a 3-month program, and so this one began on March 18th, and in 15 days from now, being June 19th, this program will in fact be over. And the essence of this program, if you're not familiar with it, it allows you to calculate a wage subsidy, which is 10% of an employee's salary, okay, that's paid. And you calculate this per employee and allows you to take 10% of that salary up to a maximum of $1,375 to a maximum of $25,000 for the employer. And it allows you to kind of keep that money as a subsidy. So effectively what you do to keep the subsidy is you short your payroll. Okay, so when I say short your payroll, you calculate the subsidy out, you reduce the amount of payroll tax that would otherwise go into the CRA, which allows you to keep more money into the business to invest and spend on other things, and away you go. Now, look, by shorting the payroll and keeping that money, the CRA has said, look, that subsidy is going to be in fact taxable. So if you're a corporation or you're an individual, just be mindful of the fact that anything that you get, you're going to have to pay tax on down the road. A couple of things here. If you haven't claimed this particular subsidy for whatever reason, depending on your circumstances, this isn't if you didn't use it, you've lost it kind of deal. In fact, you can catch up, with future payroll remittances by shorting those. If that doesn't, carry the day, you can transfer it to next year's payroll when we're, that far down the road, or the CRA will in fact, refund this. Now, just, I guess, one last comment on this before I move on to the 75% program is that, if you'd been making your claims, maybe in period 1 or period 2 for the 75% program, there was this awkward calculation that required you to pull out the 10% wage subsidy out of your 75% wage subsidy calculation. So that was out there for a while. I think the CRA sort of realized, and Finance Canada realized that was a nuisance. So you can elect not to do that now. So a bit of administrative help there for what was sort of a difficult process. So the 75% wage subsidy program, this is clearly the more important of the two wage subsidy programs, especially as businesses are recovering. So we know that this particular program here is really to prevent further job losses. It's encouraging employers to rehire workers that may have been let go, or just to maybe kind of keep employees sort of idle as businesses bounce back. I mean, one of the things that kind of caught me, I guess, in terms of how effective this program could be is that, in a lot of situations, when we're looking at this, if an employee is making $25 an hour, you're in fact able to utilize this program. Like, your out-of-pocket cost, after, considering cash flow issues, is $6.25. So there's a fairly significant subsidy. Now, initially, this program was in place for 12 weeks. Okay, so from March 15th to June 6th. And over those 12 weeks, we've got 3 periods. And so, in and around, I guess, not too long ago, I mean, businesses were starting to reopen and starting to think about what things are going to be looking like. There was a sunset clause in the legislation that allowed the government to say, look, we're going to start this for, a 12-week period, but we could extend this out to September 30th. So, in and around the middle of May, I think it was on or about May 15th, the government said, look, we're going to extend this program out to August 29th. So this is now a 24-week program. Again, which helps employers kind of look down the road, assess their situations as things are opening up and getting going again, and there's some level of certainty here that the subsidy is going to continue. So I think that's by and large very helpful. Now, in terms of claiming this subsidy, the current deadline right now is that, look, you have to get this subsidy application in for any of these periods before October. We're expecting that to probably change. And the reason why I say that we're probably expecting that to change is that, the October deadline was first framed up or built on the fact that the program would only go to June 6th. Now that they've extended it to August, you would think that it would make sense that they would extend the application too. But, stay tuned for that. And, we'll definitely need to confirm that. So we know here with this program that, when we talk about the 847, per week, what the government has said is they've looked at, what is the maximum earnings for CPP purposes. So as an employer, you contribute to CPP. As an employee, you do the same. That number is $58,700. So what the government has said is, look, we're going to take the CPP max amount. We're going to divide that out by 52 weeks, and we're going to apply 75% of that. And that's where they kind of came up with this subsidy that, they're willing to subsidize up to $847 per week. So again, the good news here being is that, this program is certainly going to continue, out till the end of August. And I think, a lot of employers, especially dentists or, medical professionals that had their offices closed, this probably wasn't really that effective while you're in fact totally closed. This is a really important program to utilize and access, as you kind of recover and, find your way again. So I think, a couple of things that, we need to kind of be, on the lookout here for, over the next, 7 to 10 days. And again, when the government announced that they were going to extend this program, that was mid-May. They said they needed about a month to do that. So that brings us to mid-June. We know that the government right now is consulting with key businesses and other labor representatives, and this was over the next month, but that's bringing us to June 15th. And they're looking at adjustments to the program. I mean, round one of the program was just that, one round. And just like we've seen the government do with lots of other programs, is that they kind of just get it onto the road, so to speak, and then they make adjustments and tweak it, if you will, to get this thing to work as best as possible. So again, stay tuned for what these things, may or may not look like. I mean, we know that they're potentially looking at maybe some adjustments, or they're looking at that 30% revenue decline. Again, that 30% revenue decline was one of the keys for getting into the program. It was 15% for March, 30 for April, 30 for May. So again, stay tuned on that. They're going to be, I think they're going to be further considering, the seasonality of some businesses and just different situations as they launch this. Again, some programs, the program will have to have probably a little bit more flexibility here. There are some limitations with the program if you've undertaken an amalgamation or a reorganization in the past, 12 to 24 months. Again, I think they're going to be fixing that up. Again, information is forthcoming on this. So again, stay tuned on that. And what they have done here is they've really said that, look, they're going to extend the eligibility to Indigenous government-owned corporations that are carrying on businesses, registered Canadian amateur athletic associations, and non-public colleges and schools. So more information is coming on this. And again, this would be a really critical tool for a lot of employers, especially in the healthcare space. So just a couple of things on the Canada Emergency Response Benefit, and I'll just do 2 slides here. And so, the slides that I just discussed, I mean, those were employer subsidies. So those are subsidies that go to an employer to help subsidize wages. Conversely, this is a subsidy that's geared towards the individual who's in fact out of work. Okay, so very different. And I'm going to go talk about some concepts, because as we get back to work, there's lots of questions about how CERB interacts with the wage subsidy. So these are just maybe some fundamentals to be mindful of as these decisions are being made in practice. So the legislation looks at this concept in terms of your eligibility for CERB, that you're a worker. You've got to be at least 15 years of age. You've got to be resident in Canada, and you had to have total income of at least $5,000 from employment or self-employment income in 2019, or in any 12 months leading up to your first application. The government will also consider non-eligible dividends as an entry point into this program. And again, so that once you're a worker, you're going to be eligible for the program if you've lost your job because of reasons related to COVID-19, or your EI benefits have ran out, or you're not in fact eligible for it. The CERB program's there to kind of pick up the slack. So again, when we talk about questions and concepts, and we'll probably get into this, where the wage subsidy and the CERB program, they're 2 different programs. Absolutely, there is some overlap, and how do they interplay with each other? These are administrative points here that the government has raised. This is by no means legislative, but these are clear administrative points that the government is allowing. Okay, and so when we're thinking about CERB eligibility, once you're eligible for it, one of the things that the government says is that, the applicant cannot have earned, more than $1,000 in employment and or self-employment income for 14 or more consecutive days within the 4-week period of the first claim. Okay. And then you get into a second claim. And then when you're into the second claim, this $1,000 rule works, but it applies to the entire 4-week period. Okay. So the first claim doesn't necessarily mean like, back in March for somebody. The first claim could be, the period that actually starts next week, because somebody just lost their job and they've gone on this. So the periods are different depending on who you are. The other thing to keep in mind with this program here is that this benefit is available from right now as it stands, from March 15th all the way out to October 3rd. And you have to make your application before December 2nd, 2020. One of the things that I think is in fact helpful, and I sort of alluded to it with the wage subsidy, is that the wage subsidy is based on 4-week periods. The CERB runs in tandem with the wage subsidy. So just, briefly, we're going to be changing gears here, and I just want to point out, maybe some new things here. I'm not going to be diving into these, loan programs or the rent programs a whole heck of a lot here. We're going to get to the questions, but some good information here in terms of the Canada Emergency Business Account program. So this is the $40,000 loan, which you may know it as. And so when the program first launched, it was definitely geared towards what they thought were employers. Okay, and one of the conditions for eligibility is you had to have a T4, you had to have been paying wages in 2019. Now, look, if you weren't paying wages in 2019 because you're a sole proprietor and you didn't have employees, or maybe you're a business that relied on contractors, or you're a business that just paid dividends and you didn't have this, these were all sort of gaps that the government, has now recognized with. And you know what, on May 19th, they said, look, we need to expand this program. More businesses, need access to this. And we want to expand access to this based on the business's economic situation, not on how, the business was making payments in the prior year. So I think that, by and large, if you're a healthcare professional, physician, dentist, this is probably very helpful. And if you haven't had the opportunity or you've tried to apply before, you may want to consider going back to the bank and seeing if this is right for you. These are sort of the general rules as they relate to the loan, and probably everybody's pretty familiar with this. And again, it's intended for non-deferrable operating expenses. The one thing that we would always say to our clients here is that, look, we know that 25% of this loan is in fact going to get forgiven at the end of the program. If you want to have that forgiveness, definitely be accountable for how these monies have been spent, and be able to demonstrate, just that if you want to, participate in, that upside. So just lastly here, and this is, again, another, important tool that the government has in their toolbox, and it's the Canada Emergency Commercial Rent Assistance. So this is, the program. This was announced at the end of April, was revised in May, and the portal just opened up on May 25th. So, under this particular program, there's 3 parties. There's the government, the landlord, and the tenant. Okay, and what ends up happening here is that the government provides a loan, okay, to the landlord, okay, on the basis that the landlord enters into a rent reduction agreement with the tenant, and so if they enter into this rent reduction agreement with the tenant, basically what has to happen is the landlord has to agree to sort of eat 25% of the rent, and so the tenant would pay 25%, and the federal government's loan, which is 50% of the rent for the months of April, May, and June, would be forgiven, provided the terms and conditions under this program are followed through with. So we're learning a little bit, more and more about this program as it gets rolled out and as people are applying for it and as we start seeing it in action. So there's a couple of qualification things here. So, the commercial property owner, in fact, has to qualify for this. So, you have to own commercial property that's occupied by one or more impacted small business tenants. We'll talk about that in a second. I think I'd mentioned that you had to enter into a legally binding rent reduction agreement for the period of April, May, or June 2020. And again, while you're into that rent reduction agreement, there has to be a moratorium on evictions for the period during which the property owner agrees to apply the loan proceeds. And then there's declarations that also need to get signed here. So an impacted small business tenant, might be here on the phone. You're not paying more than $50,000 a month in gross rent, which has been defined. You're generating less than $20 million of gross revenues. And the key thing here is that you really have to have had experienced a 70% decline in sort of pre-COVID revenues for the months of April, May, and June. So again, a good program here if you can negotiate this with your landlord. So I think at this point, that's the conclusion of my presentation, and so I think I'm going to turn it back to Mike, who's going to moderate the questions and answers here.
Yeah, that was awesome, Danny and Marty. Thanks, guys. So we've kind of had a list of questions. There's been a few questions that have come through, or 3 questions that come through on the feed. If you have more questions, feel free to fire them into the chat, and we'll try to get to what we can get to here. But I guess the one of the questions that came through on the registration forms, and I think it's one that we've probably all been hearing from our clients between the 3 of us. And Danny, I think you touched on this a bit in your section, although one more question came through on the chat is, we're reopening, we're looking to bring back our employees, and we've got groups of employees that, perhaps they fall into 3 different groups that are not wanting to return to work. A, they have legitimate health and safety concerns. B, maybe they're saying they have legitimate health and safety concerns, but they really don't. Or C, as Danny put it, they enjoy the $2,000 a month for couch surfing. So, no, Dan, if you have any more to add on that. But the one question that did come through on this topic was, what if an employee is making demands for, PPE or anything like that that would, exceed what is, sort of generally assumed best practice for health and safety requirements. So you've already gone and met all the WCB, you've met your provincial regulators' requirements, and you've got an employee who wants you to go above and beyond that. Do you have any thoughts on that, Danny?
I do, yeah. Thanks, Mike. It's a good question, and it's probably one of the more challenging topics. It's a conversation I'm having daily with different clients in different industries about returning and folks who are refusing. So, a couple of general points that I'll repeat: treat every request on its merits. Don't take a blanket approach or one size fits all. If to respond directly to this question, if people are saying, "Look, I'm not comfortable in anything less than a hazmat suit," that's not reasonable. And if you have met the regulatory requirements, you've got your WorkSafe safety plan, you're complying with all of the safety standards that the provincial health officer and any other body is telling you, then you push back and say, look, we need you to come to work. Is there something specific about your circumstance or your particular concerns that we can address? Because maybe with some more information about the steps you've taken, you can actually put their mind at ease. But ultimately, you can insist that someone come to work. And unless they have a genuine medical reason, which you would need to accommodate, perhaps by just having them remain at home, you can insist they come to work. We've heard a lot of, I'm not coming back until there's a vaccine. Well, who knows if and when there's going to be a vaccine? And unless someone has a genuine medical reason that they can't even come to work despite all of the safety measures in place, either you're telling them we need you back, or you're telling them, look, you may be at risk of losing your employment here because we're not giving you more PPE, we're not doing anything more, and it's not for the employee, it's not the tail wagging the dog here. You're the employer, you set the rules, you create the framework, and you're entitled to stick to that pretty firmly.
Awesome. Marty, I don't know if you have any thoughts on, employees refusing to come back to work and, we leave them on, say, temporary layoff. Maybe they don't have a legitimate concern, or maybe they do. Is there any impact on that employee's entitlement to CERB or your ability to claim wage subsidy if you have them on paid leave?
Yeah, I guess the one thing I would just sort of outline, if you do have somebody on, paid leave, and whether they're coming or going, or their employment status is changing, there's this concept of eligible remuneration that, you need to kind of tick the box in order to claim wage subsidy. Okay. And it's a really important concept. And so the idea here is that, again, when we're within these periods, we're paying employees in respect to that week. Now, one of the things is that employee can't have gone more than 14 consecutive days for wage subsidy purposes without remuneration. Okay, so depending on when you're bringing people back or you're maybe letting people go, there is wage costs that are in fact being paid out there. So just be cautious of that, because, the wage subsidy, when I use the example of, if it's $25 an hour, and after the subsidy, you're paying $6.25. Well, that's good. There's a cash flow issue, but if you don't in fact qualify for the wage subsidy, like having a $25 an hour outflow versus, $6.25 is quite a bit different.
Awesome. That's great, guys. So another question that I know I've heard a handful of times, I think you guys have heard as well, is we're opening up our practice, and the patient flow is low right now. Don't necessarily require all my staff back, but I'm gonna bring my staff back, and I'm gonna try to keep them below the $1,000 a month, because if I can keep them below $1,000, that doesn't impact their entitlement to the CERB. Can I still claim the wage subsidy, or am I causing issues in trying to do that? So I think there's probably, I imagine, an employment law issue here, Danny, and some issues around the tax side of things, Marty.
Or do you want me to maybe just start? Why don't I just maybe start with the tax side of things? So I would say here, like, when we were sort of doing the presentation, we were talking about the overlap between the two programs and possibly the interplay here. So I think the answer is, like, theoretically, if somebody's being paid less than $1,000 and you're claiming the wage subsidy, like, there's nothing in the wage subsidy legislation that says, time out, you can't do that, out you go. So, having said that, I think that, the administrative position that the government has set, allows for some flexibility. I mean, there's going to be some ebbing and flowing, and people are going to be coming and going. Things are not going to be necessarily consistent. So again, just keeping in mind maybe what period the employee is in, whether it's period one or their second period, because that $1,000 kind of works differently depending on the period. The answer could be, if we're just utilizing this to manage the situation, I think that's one thing. Now, like, if you're deliberately planning into this to maybe manipulate the system or to do something different or untoward, I would just sort of caution that the administrative position's $1,000 a month. The legislation is pretty hard and fast, and I think if the CRA came across a situation they thought was maybe offensive, they would tactically just go to the legislation and probably ignore their administrative position. But again, I think that if things are well intentioned and you're trying to do your best and get people back to work, that probably shouldn't be an issue.
And I'll just jump in from an employment law perspective. I think that, just to echo Marty's comments to some extent, the intention here is to I think act in good faith for everyone. It's not to find creative ways around or through perhaps loopholes, because this is emergency legislation that came through. From an strictly employment law perspective, as long as the employee is earning what they've agreed to and what you're perhaps what they were earning before, then whether it's a combination of wage subsidy funds and employer funds, I don't think there's a huge problem there. We know the federal government is encouraging employers to top up the wage subsidy to get everyone back whole. I haven't seen a lot of that happening in practice. But I do think that there is some risk with trying to come up with creative ways to have employees earning money, earning up to $1,000 and perhaps only just shy of it, and then getting the wage subsidy for the balance, when perhaps there's other ways to do it and other ways to manage it. But whatever you do, and this sort of responds to another question I think that came in, Mike, is get agreement from an employee to whatever way you're remunerating them, whatever system you have in place. I would get them to sign off and agree on whatever their income is going to be, and be it temporary or permanent.
And I guess maybe just one other thing: if it didn't work and that $1,000 is breached, I mean that's something the employee has to pay back, okay, which would be their CERB, okay, which is $2,000. So I mean that could potentially be, certainly something that an employee definitely doesn't want to do down the road. So I'd just be mindful of that again, that if this, whatever reason, if it didn't work, I mean, there's good reasons why it could. Definitely part of the risk resides here with the employee, which, if I had to guess, the employee might be sort of fairly unassuming.
That's great. Thanks, guys. The next one, I think this one might be directed more to you, Marty, but Danny, you might have a couple comments on it as well. I think a lot of practices started to open their doors last week, maybe even the week before, but I'm kind of getting in particular last week. So, post May 25th, you would have rehired your employees May 25th or, later in that week or even early this week. What's the implication for claiming the wage subsidy for the May 10th to June 6th period? So I've hired my employees with a week or 2 weeks left in that claim period. Can I still claim the subsidy for those employees, or do I have to kind of think that through a little bit, Marty?
Yeah, and this is a really good question, because this is coming up quite a bit, and I've got a couple of emails I've got to respond to on this matter when I'm done here. So again, we're in period 3 here. Okay, so period 3 runs from May 10th to June 6th. So today being the 4th, we're almost at the end of it. Okay. So again, what you want to be cautious of here is that, if you bring someone back in this example on the 25th, well, I mean, they've definitely gone at this point anyways, they've gone more than 14 consecutive days in this period without remuneration. Okay. So that's one of the conditions that you have to, meet in order to claim the wage subsidy here. So if we brought them back on the 25th and you're paying them, whatever it is you're paying them, I'm going to use the example of $1,000 from May 25th to June 6th. When it comes time to, going and claiming the wage subsidy of $750, for example, okay, well, if you're not eligible for it, your out of pocket cost here is $1,000 and not $250. So when you're looking at the dates and the hiring dates, I mean, you need to make the best business decision first and foremost, and the best business decision will drive when you need to make the hire. A lot of people are considering to hire people sort of next Monday. That works for some people, but not everybody. And the reason why they're doing that is because it lines up nicely with the wage subsidy program, and it lines up nicely with the CERB program. So that's fairly straightforward. But again, that's not for everybody. So if you're in this situation where you're paying somebody, again, from that $1,000 from May 25th to June 6th, okay, $1,000 probably shouldn't be too much of an issue. But if you want the wage subsidy, they've thrown out this concept of, retroactively paying people. So if we start retroactively paying people within the period, or maybe even go back further, that's fine. That's helpful to the employer to claim wage subsidy, because, we start checking the boxes and we get wage subsidy. But again, as the employee starts receiving or earning money that's in excess of $1,000 within one of these periods, they may be forced to pay back their CERB benefit of $2,000. So, certainly calculate it out and make sure that whatever you're doing isn't going to hinder or cause issues financially for your employees. And again, using sort of the best business decisions as possible, I'd let that sort of guide what you're going to do. But again, when you start retroactively paying people, it certainly adds a little bit of complexity and some admin for sure.
But just to add to that, if you are going to retroactively pay people, we had a discussion about this offline beforehand. We're talking about employees who were existing employees who are either on a leave of absence or a layoff, and you're looking to fill in a gap where they weren't earning wages. Consider also that there are some additional costs, and you've got to look at vacation pay for the wages that you pay them, even if it's for a period of time when they're not at work. The view is that wages paid do accrue vacation. And also, just to reiterate that there may be an obligation for employees to repay anything that they've received through the CERB. So if in your recall notice, if you're intending to repay to retroactively pay them, make it clear that that could have an impact and that it's their responsibility to repay. I like to spell it out very clearly that you, the employee, may have to repay it, and it's your responsibility, and we're not going to be the ones to track it down and decide or take it on your behalf. So they're sort of making a decision with their eyes open on this one.
That's great. So another question that came up on the registration questions, and I know it's a question I think we're all hearing a lot as well, is there's a lot of talk that there is potential for another or a second wave of COVID, and and does that force us into further shutdowns? So, as a practice owner, is there anything proactively on employment law side of things, or Marty on cash flow management or taxation side of things that I might want to be considering now to prepare myself so I'm mitigating any risks to my practice if that second wave does come?
Why don't I lead off on this one from an employment law perspective? I think the first thing you should be doing is when you are recalling people to work, if you have that opportunity in a recall notice, to specify that there may be a need for future layoffs. If you've already recalled or you don't have that opportunity, like I mentioned in my slides, be open and transparent that this may come up again. You may even want to create a policy that talks about the need for flexibility and the potential of layoffs in the future due to business changes or business exigencies. So I do think it pays here to be proactive. The fact that you've laid people off without their objection and recalled them without their objection does give you some leverage to say it has become a part of the terms and conditions of their employment already. So that is good to know if that has already happened. But I would document it somehow, either in a policy or ideally in a contract, a recall notice that there is the potential for future disruptions like this.
Great. Well, I mean, just a couple of things that I think I would consider from maybe a financial or a tax perspective is that, in the event that there is a second wave, and, hopefully there's not, but it's best to be prepared. Look, this one of the tools here might be to sort of forecast a budget and really understand kind of where you're at financially. Okay, do you have savings that could kind of carry the day a little bit? To the extent that now that you're opening, if you're making some money, can you repair some savings or put some money aside? Again, just being cautious about maybe what's to come, because we've just lived through a bit of a shutdown, and we definitely know what that looks and feels like. But again, maybe having access to credit, having conversations with banks now, if you haven't already done so, would certainly be wise. If you've got suppliers, maybe negotiating your terms and conditions. We've talked about the rent subsidy just briefly, with your landlord. But I mean, to the extent possible, I mean, and again, just making sure you're making the right business decisions is to possibly control your spend and be positioned to maybe absorb another shutdown. Now, like on the tax side of things, or the tax side of the world, September 1st is sort of this day where there's been a lot of relief given when we're talking about the deferral of income tax payments, whether it's personal or corporate or GST. Employer health tax provincially has been deferred. All of these things have been deferred. So I think one of the things that you certainly want to be mindful of is September 1st isn't all that far away, and all this stuff's going to have to get paid at one point. So when you're thinking about anything that you've been deferring going through the first wave, just be very mindful of what's actually coming due, and make sure you're best positioned for that well ahead of time.
Right on. So we're coming up close to an hour here, so let's see if we maybe get one more question in here. There's one question that's come up. I think it's sort of a follow-up question a couple of times here around the wage subsidy, and the question I think sort of centers, or the two questions center around topping employees up. So maybe an employee worked, you had them work 5 days a week pre-crisis, but now they're only working 4 days a week. But maybe you want to top that employee up for the fifth day. What are the considerations around that? Can the wage subsidy be claimed? Are there any employment law issues that might present themselves for paying someone an extra day while they're maybe not working that extra day?
You want to lead off here, Marty?
Sure. I guess, I mean, the first thing I would consider, again, and I guess maybe just kind of going back to, what we were just talking about, is number one, it's a cash outflow. And look, your employees are your most important resource. So, you certainly want to do, best as possible there. So if you're going to be topping up the employee for that extra day, you certainly want to make sure that the wage subsidy is going to avail itself. And so, look, just to take the time, run the particular employee's situation through the formula. It's pretty straightforward. and you probably should be able to get the wage subsidy on that. Now, I don't know if you're going to necessarily get the full amount on that 5th day, but you might get 75% of it. But that 25% cost is, something that, really makes sense from a business perspective. That would be a business decision. Then, you know what, that would be, something you'd certainly want to consider.
And from an employment law perspective, I don't have any real concerns there. I guess the challenge or the issue you have to address initially before you even think about topping up wages is you've had an employee working 5 days a week and now they're working 4. So you've effectively reduced their compensation by 20%, which in the ordinary course is going to be considered to be a constructive dismissal. We didn't get time to dive into that concept tonight, but you at least need to get some agreement from the employee that those are the new terms and conditions, that they're going to agree to working a 4-day instead of a 5-day week. It may well be that that's all you can offer, and that's fine. And if you get that agreement, then you can avoid an argument on that. And then the way you use your SUVs is the way you choose to use it. It doesn't really matter to the employee, so long as they're getting the income that's agreed. It doesn't really matter the source of the funding for them.
Well, that's great. Thanks, guys. So I've come up and sort of past the hour mark. So we're going to wrap it up there. I know there's a handful of questions that didn't get addressed that came through the live chat. So we'll actually try to do our best after this session just to just maybe fire off quick comments to you via email if we didn't get a chance to answer your question. So beyond that, if anyone has any questions on the employment law side, please feel free to reach out to Danny. His contact information is there on the screen. And likewise, anything on the subsidy side of things, taxation side of things, myself or Marty or any of the MMP practitioners in an office closest to you should be able to help you out. So with that said, thank you everyone for spending an hour with us this evening, and hope everyone got some value out of this chat, and look forward to chatting with you all soon. Take care.
Thanks, everyone.